Hello, and thank you for joining us today. On behalf of BakerHostetler and PwC, we would like to welcome everyone, including members of the media, to today's webinar, Tracking the SEC's New Agenda, Hot Topics in Securities Regulation, Accounting, and Enforcement. This presentation will last 60 minutes. This webinar is available for CLE credit in California, New Jersey, New York, Pennsylvania, and Texas, and is pending approval in Colorado, Florida, Georgia, Illinois, Ohio, Virginia, and Washington. For all other states, credit will be applied for as requested. Please be advised that there will be 2 points during the program where we will pause for CLE codes. During this time, a code will appear in the slide deck you see on your screen. Please make sure to write down this code if you are seeking CLE credit, as you will be asked for it at the conclusion of this presentation. A CLE and program evaluation will be available immediately following the conclusion of the webinar at 3 p.m. Eastern, prompting you for your bar number and the 2 CLE codes. If you have questions throughout the program, you can submit them via the Q&A box in the Zoom platform. We will do our best to address them throughout the program. And now we'll turn it over to today's moderator, BakerHostetler's John Carney.
Hello, everyone. Welcome to Hot Topics on a very hot day. We have a great agenda. We're going to pack a lot in less than 60 minutes. But we have a lot of things happening. We have a new chairman. We have a new incoming director of enforcement. We have a agency, coming out of a pandemic, a telework type of lockdown, as well as the economy. And so we thought collectively, both Baker and Price, this would be a great time to actually stop and, get a little situational awareness as to what's going on. And so we're going to be talking about, really what is the SEC's new agenda under the Biden administration, which is clearly, pro-regulation. And we're going to cover these hot topics, the SEC's voluntary information request, initiative to public companies, a potential crackdown on insider trading by senior officers, cryptocurrency, special purposes acquisition companies, SPACs, ESG and climate change disclosure regime. And we believe, that three of us believe, that this is some of the key things that that registrants and counsel and accountants should be looking at as the regulators, get back to work. Next slide. So just a little bit about me, John Carney. I started my career as a CPA at KPMG for 5 years, was a manager in New York, New Jersey, law school, then SEC for 5 years in enforcement, investigating and trying cases for the division. Then a little more than 10 years with the Department of Justice, where I prosecuted and tried insider trading cases, foreign corrupt practice cases, financial fraud cases. And for the past 15 years, I have been at BakerHostetler, where I co-chair the Securities Defense Group. Next slide, please. Teresa, you want to introduce yourself?
Yes, I'm Teresa Goody-Guillen. I'm a partner in BakerHostetler's DC office. I started my career at a law firm in private practice, working on a lot of litigation matters and derivatives and a laundry list of different areas. And then moved to the SEC in the Office of General Counsel, where I litigated on behalf of the agency, and I worked with all the different divisions for various projects and investigations inside, and in my capacity as legal counsel to all the different divisions. I also served to the right hand of former SEC Chairman Harvey Pitt for many years, and worked extensively on a lot of digital assets and blockchain technology after that at my own firm, and joined Baker a few years ago. My practice straddles over both business and transactional work, a lot of it related to securities compliance, whether it's disclosures or private offerings, also with the blockchain and digital assets, as well as white collar defense and a lot of securities investigations and defense work.
Right, next slide. And Sandy, why don't you take a few minutes and tell us about your practice?
Sure, happy to do so. Thanks for having me here. Sandy Parada, I'm a partner in PwC in our cyber risk and regulatory consulting practice. My focus area is in forensics and financial crimes across the spectrum of financial and economic crimes, whether it's fraud, corruption issues, money laundering issues, sanctions. Essentially, you know, when things go badly, we're on the case. But doing that not just in a responsive mode, but also in a preventative, prophylactic timeline as well. So very much looking forward to this conversation with you and Teresa, John. So happy to turn it over to you.
Yeah, and again, we thought that this would be a great group because we have, you know, somebody who's in Pricewaterhouse, you know, sees what the auditors are seeing, as well as, you know, people who are in enforcement, Office of General Counsel, and defense. And so hopefully we have these issues surrounded. So next slide.
Mm-hmm.
So one of the things I think we want to, you know, focus people on is that is the administration, the SEC, you know, really going to be playing catch up? And so the three of us spend our days, you know, defending cases or being involved in cases with the SEC, and it's really been quite a remarkable transition by the staff as they made the switch to in-person testimony, to teleworking, virtual testimony, depositions. You know, I know Teresa and myself have a number of cases that went from live to you know, to Zoom over the last year. And it was, you know, could have been a little bit of a bumpy transition. And I certainly thought that the staff was not moving as quickly as they could because of that. And I think that's been borne out, because one of the when the staff reported their numbers for 2020, and remember, only about half of that was covered in the actual lockdown, the pandemic, because they're on a September 30th year end. They were down to 715 enforcement actions. I mean, and they were in all the areas, you know, from financial fraud, disclosure, cryptocurrency. But if you look to see, in 17, they were at 754, in 18, they were at 821, and in 19, they were at 862. So that's about a 17% decrease. And about half of it is, you know, was during the period of time when the agency was locked down. So I think that's important. And Teresa, what do you think about those statistics?
I think it shows too that the SEC, just because it was on lockdown, it didn't have those cases go away, but you know, they've kind of been stayed. And so while we expect there to be a very aggressive enforcement under Gensler, I think we can expect a lot of these cases to come back. And so I think we'll see a huge upsurge in cases coming up soon.
Yeah, and just anecdotally, we've been seeing in our practice, we've been seeing that, you know, there's certainly what appears to be some pressure on the staff to try to get cases in and filed by September 30th. That's going to be very difficult to do. But I think you know, if we're setting the table here for this discussion, what's important is that if it wasn't like 17% of the cases went away, or there were 17% less violations out there. It's just that, you know, you cannot move as nimbly and as quickly when you have to have all the COVID restrictions that were in place. And so now that I think it's our collective understanding that, you know, the staff will largely be back in business in September in person, as many law firms will be and accounting firms. Will you see a surge? I think the answer is you're going to see a surge, and this is before we're talking about a new enforcement minded chairman and a new, you know, focused former prosecutor. So I think this kind of sets it up. Next slide. So with that, I mean, people who've been following, you know, the chair knows that he was very effective and very forceful as the CFTC chair, and he's made it no secret that, you know, he means to hold individuals and companies, you know, accountable without fear or favor, everywhere. And so I you know, he said the idea is pretty simple. We need rules of the road and a cop on the beat to protect everyday investors. So you have somebody who's at the helm of the ship, who wants to do this, and he's going to have these agenda items that we're going to talk about here. But again, dealing with the backlog, dealing with the staff that needs to get going, and his pick for for enforcement director is, in my mind, really, really interesting. Next slide, please. So there are many cases where you go with somebody inside the agency, somebody who is steeped in the history of how the division works and how the commission works, or you go to the outsider. And that certainly has happened in the past. But Gurbir Grewal is currently the Attorney General for the state of New Jersey. I know Gurbir. I was in the U.S. Attorney's office that he was in. We both ran the securities fraud unit at different periods of time. And he's an incredibly hardworking, effective attorney. He has a fantastic experience. But if you look at his experience, he was a federal prosecutor in Brooklyn, then the chief of economic crimes in New Jersey, and then the chief law enforcement officer for one of the most populous counties in New Jersey, and then the attorney general for the entire state. And in each of those positions, he's actually wasn't afraid to crack eggs and make omelets. But you have somebody there who, in his own words, he wants to uncover and prosecute misconduct. I'm thinking that you're going to have somebody who's very, very aggressive, who looks at it from a prosecutor's point of view, somebody who's going to want to push cases to trial, and not going to be afraid to push the staff. And so, again, you have this backlog of cases, or I won't say backlog, but you have this reduction in number of cases we think is going to come forward. Then a very aggressive new pro-prosecution director. I'd be mindful. And one other macro thing that I want to talk about is on the next slide. It's a little bit hard. It's a little bit hard to read, and then I'm going to ask Sandy and Teresa to kind of chime in on this. But it's always, for those of us who practice in counsel, the possibility of a whistleblower, used to be rare. And now it is commonplace. And this chart came from the SEC's report to Congress in the fall of 2020. And what's important about it, though, if you look at the gray, you don't have to see the exact numbers, but if you look at each of the bar areas of the gray, those are the number of whistleblower reports, to the Division of Enforcement, over the years. And you can see whether it's in financial fraud or insider trading and market manipulation. In just about every category, the numbers are up, and I think that's significant. Like Sandy, you've clearly worked on cases where there's been whistleblower. I mean, they take a long time, don't they, to get from the first word into an action is filed?
Well, yeah, but there is the time it takes for it to make its way through, but the process behind that, which we'll talk about later as well, is going to start unfolding as soon as the SEC starts to hear about a potential matter. In this case here, I think I look all the way to the left here around corporate disclosures and financials, where it's not only the highest, but arguably the biggest uptick year over year. That also reflects, if we look at the spring 2021 SEC agenda, their RegFlex agenda, many of the rulemaking that's in the works for the upcoming year is very much all around disclosures. So there's going to be sort of those two angles, the two fronts where this issue is going to start unfolding on the enforcement side, which is where the whistleblower program will feed into, but also it's informing the rulemaking that is also going to start unfolding under this new chairman.
And Teresa, when you look at numbers like this as a SEC defense lawyer, what do you think?
One of the things I wonder is how the SEC is possibly going to make it through all of these SEC whistleblower complaints. And so, also coming from the Office of General Counsel, when this office was being created, the triage system that they go through kind of goes into three different paths as soon as it goes into the agency. You look at how difficult it might be to really get the big violations in the big cases to rise to the top, especially for those who don't have attorneys representing them and able to really describe the egregiousness and the seriousness of the securities laws violations. But it's going to be difficult, I think, for the SEC to make it through all of these complaints, since they already have trouble getting through the complaints before this uptick. So I'll be, curious to see that. Also, if, with so many complaints and the and the difficulty it can be to decipher the egregiousness of the conduct, especially when somebody's not represented, if this will lend itself to more smaller violations too, of more, kind of the broken windows that we've looked at before, and that type of a policy.
Right, and one of the things, I didn't want to kill the audience with a million slides from your report, but other slides actually show the origin of where these things are coming from, and a lot of them are coming from the BRIC countries, Brazil, Russia, India, China, that there are problems, and and my over 25 years in law enforcement on one side or the other tells me that when there are crises and there's chaos, there's misconduct. And as we get back, as the staff gets back to being in the office and really gets back to traveling again, which will take a little while longer, I think. I think my personal takeaway is there's no shortage of cases, there's no shortage of complaints, and there's no shortage of an aggressive chairman and director. And those things you have to, you always have to look at your conditions, as you go forward and think about your filings and your disclosures. And I think that's the first jumping off point I wanted to say, look, we're primed for a very pro-enforcement year ahead. Next slide.
Yeah, and John, it's interesting because I've heard the new director of enforcement described as, be ready to get prosecuted for jaywalking on your way to go rob a bank, right? And so, thinking about that perspective and that approach with whistleblower complaints too, like you were just saying, it seems like it's just going to be a much more active enforcement environment.
We agree.
Well, and John, I think 2020 was also a banner year for whistleblower bounties compared to prior years. So in line with a banner year for settlements, same thing with encouraging individuals to report concerns in this behavior.
Right, and I think, again, to the folks in the audience, the three of us have been doing this a long time. We know that if things are moving quickly, something gets, from report to resolution is 2 years, including individuals. And so, again, when I see those numbers, I'm seeing like these are subpoenas that are going to be coming out, and the reach out's going to be happening. Kristen, do we have a CLE moment here?
Yes, please record the code SEC1 for the post-program evaluation. Please make sure to write down this code if you are requesting CLE credit, as you will be asked for it at the conclusion of this webinar. SEC and the number 1.
Okay. Sandy, I think you're going to pick up here, right?
Yeah, of course. So I thought one of the things that could also launch us into the rest of this session, picking up where you left off around whistleblowers, is gearing up on what from a company corporate perspective they should be expecting. One area is what's called SEC Voluntary Requests, and as we framed it here, it's an offer you can't refuse, calling out to a certain famous movie of the past, if you will, but it provides a company a chance to provide information on a voluntary basis, even without the power of a subpoena behind that request. Now, it is a request, it is voluntary, but it's never as light and voluntary as it sounds. It's not informational. It's really, it puts a recipient on notice. It's a warning. There's consequences, obviously, to not doing it. But from a process perspective, obviously, it will start with a request letter. These days, it might be an email. We'll follow with an example right after this, where the SEC will be requesting information, whether it's documents that exist or will be created, and pursuant to trying to understand, allowing the SEC to understand if there's merits behind facts that they may have, that they're looking to gather. Eventually, it may convert into a formal investigation, or it may close. Once that converts to a formal investigation, then the SEC has the subpoena powers. But until then, this process enables the SEC to get a lot of information from a particular requestee. One of the things that I teed up earlier is that it's not really optional, if you will. There are consequences to not complying. including whether it informs the SEC's views around the veracity of the issue that they may have some concerns around. They may end up seeking testimony from the company or its senior officers. And also, I think more critically, if it does convert into an investigation eventually anyway, the lack of compliance is going to be deemed as a lack of cooperation, which is important when a company is trying to resolve a particular issue. Very commonly, this will be involved or employed in sweeps, which we'll talk about momentarily, whether it's because of concerns around compliance programs, policies, procedures, but the SEC gets wind of a particular type of behavior or concern from one case and starts to evaluate how many of a particular sector or industry peers have the same problem, which is a case that we're seeing unfold now in the cybersecurity world, which is what we will launch into next. But John or Teresa, maybe you're the attorneys and you deal with this all the time. What are some of the other thoughts that you'd want to make sure our clients think about when faced with these particular unique circumstances?
Teresa?
Yeah, well, one of the most important things is, the word voluntary is such a misnomer here, right? You can't just ignore these. Voluntary doesn't really mean voluntary as we think about it. And so, it's important that you really consider this, and generally speaking, you'd want to respond. It's something obviously you've got to talk about with your counsel and everything like that, but just because you get a voluntary request from the SEC, or any government agency, I can't stress enough that it shouldn't be taken as really voluntary. That's, I think, the big takeaway.
Indeed, indeed. So let's advance to the next slide, because I think that starts to make it a little bit more real, if you will. As we speak here, starting in sometime in June, the SEC issued a voluntary disclosure request to a series of clients of SolarWinds, which had it's a hack that was in the news at the end of 2020 and impacted a lot of companies that use SolarWinds software or services rather. So with respect to this particular letter, it's the intention behind this voluntary request, if you will, is to allow the SEC to evaluate whether companies failed to disclose that they may have suffered a breach or a hack resulting from this particular exposure. And also whether or not they had disclosed related internal accounting controls that may have been deficient as well. So as part of this letter, very interestingly, actually, there's an FAQ that in the SEC's website that provides their Q&A around the most commonly posed questions. And it actually starts with essentially information that shows that their request, which they sent via secure email, was not itself phishing, as I think others who received it thought it was, understandably so, because it didn't actually say at sec.gov. But it was indeed a legitimate request. And if as part of their Q&A, number 4, in their Q&A is essentially is an offer of amnesty, if you will. Why should a recipient participate? And so as part of participating, the SEC is saying that the Division of Enforcement will not recommend that the Commission pursue enforcement actions against recipients that meet requirements. And of course, please read the fine print, if you will. Amnesty here would be, as it relates again to failing to make disclosures to the public or to the SEC in case of, in case of a breach, as well as internal accounting control failures. But they also made very clear that there would be no amnesty in cases where there were other cyber attacks that were unrelated to SolarWinds, or for other violations that may be related to the SolarWinds cyber attack, but other securities violations, for example, insider trading, which John will cover next, as well as violations of Reg FD. Another sort of, condition, if you will, or no amnesty position would be if a company was aware of the attack prior to September 2020. One of the things, by the way, as it relates to a condition to get the amnesty is actually for the recipient to address any failures in making required disclosures prior to responding to the SEC in that voluntary request. So one of the things that could happen if an entity is not going to be responsive, as we had covered earlier, is the SEC may have signaled that they may end up pursuing enforcement actions and then impose even tougher sanctions and penalties in the case of those who are non-responders. So pretty interesting time to, and timely, I think, when we think about this as an example of a few areas to think about. One is increased enforcement, two, increased focus on disclosures that this SEC may be, looking to deal with going forward. And then thirdly, increased concerns around cybersecurity and what that means and how the SEC can use their powers to protect the investors and ensure that the market is functioning fairly and supporting capital formation. Teresa, John, anything you'd like to add before we move on to other cybersecurity thoughts? Again,
just picking up, and maybe this is only because, Sandy, I'm not going to ask you to answer what an auditor would do, but one of the things I'll ask Teresa, I look at this. I look at this, and so you're sitting there. So, okay, certainly all the major firms know, accounting firms know that there's been this request, and they go in, and so it's not from the Division of Corporation Finance, it's from the Division of Enforcement. So it has an entirely different meaning. And the first question, if I'm the audit partner, Teresa, what's the first question if you're the audit partner?
Well, you want to know what all the other compromises are. You got to start looking into what the different potential liabilities are for the company, and whether any of these were actually material and should have been disclosed.
Right, and even if so this is for all of those who there are so many collateral consequences to this type of voluntary request that we've had clients who might thought, or people have contacted us that it is truly voluntary, I don't have to do it. So no, it is, but if you don't, as we've said, they can subpoena you, and the odds of you getting investigated might be small. The odds of you getting audited are 100% if you're a public company. You're going to be audited because that's what you do. It's part of what you need to do as a public company, and they're going to ask. And if they're, at least in my mind, I look at it okay, we got some time now before the year-end audits go, and now's the time to kind of get with counsel and to see, okay, really, where are we, where were we, and looking through the new lens on disclosure here, how are we doing? So that's it for me on this slide.
Yeah, with that, John, with that tee up, let's move to the next slide. Is one of the big questions around this idea of disclosure is, well, when, right? And then the question, and when and if, right? And that turns on concepts like materiality. Currently, the prevailing guidance is from 2018, which essentially was also very much founded upon 2011 guidance. And that guidance is all about disclosure and reminds how disclosures of material cybersecurity risks and incidents in a timely fashion, including those companies that are subject to material cybersecurity risks, but may not yet have been the target of a cyber attack. So it pulls in, of course, any company that in today's age is doing business, because so much of what we do is in the digital space. The question here is always around materiality and what is material. And the guidance itself does not provide any kind of bright lines around what is material. It's not so simple as a calculation, if you will. It's very much a qualitative consideration and tries to provide the principles. And again, those principles are always around the investor and whether or not a reasonable investor would consider that information subject to a potential disclosure would be important in their investment decision, or the omission of that of such information to that reasonable investor would have significantly altered the mix of the information that they're considering. When we think about this concept of disclosure, there's one aspect of it is all around incidents and when is an incident material. And that guidance talks about the ideas like, whether or not, what's the level of importance of the compromised information? What's the impact to the company's operations? We've seen examples where, a company is not able to operate, not able to, power up their even simple as emails, for example. What's the nature and extent and magnitude of that compromise related to that compromised information? And what's the range of harm from such an incident? And that that range of harm actually asks the issuer to think about, whether it's the reputational harm, financial performance of the issuer, but also the impact of potential customers or vendor relationships, litigation, regulatory. That's from the perspective of incidents. And what is challenging here is even when it seems like that's good guidance. It's interesting that if you look at, I think it was 2018 or 2019, one of the commissioners then had suggested that only 10%, so 90% of incidents remain undisclosed. Only 10% were disclosed, and yet these were not, they may not have been small incidents, but certainly there's the complete lack of disclosure or not very timely. So some of these incidents aren't disclosed until perhaps 3 months later. And so clearly there's a lot of questions still around materiality. We'll cover that. And this is, this is part of the underpinning, I think, of what this go forward SEC team is going to try to sort out, and whether the principles-based concepts are enough, and how then to provide a little bit more clarity and specificity around what is a disclosable event. The other area I'm not going to touch upon just in the interest of time, but is shared here, are the risk factors, whether or not there is an incident, but the risk factors to a business, to a filer in terms of the cybersecurity and cyber risk, and some considerations around when are those risk factors something that might be potentially important to an investor to consider. One last point I'd make is the guidance is also very specific in saying that if there's an ongoing internal or external investigation around a cyber incident, that alone is not a basis for avoiding a disclosure. So it may still be active and ongoing, but again, the company will need to consider whether or not they have an obligation to disclose to the SEC and to the market. Next slide.
I just want to say too, it's interesting that as the SEC starts considering this, I think it's important that especially people with the knowledge in national security and how these kinds of disclosures, what types of disclosures are actually could be damaging for national security. I mean, I think that's particularly important too for people to come forward and for the SEC to get the public's kind of view and collective expertise.
Right, and the new incoming director too, while not having a long history in securities regulation, has actually expressed interest as the Attorney General and prior to that in this area of cyber. And I know that's one of his pet projects. So you can count. I think you can count on this getting a lot of attention.
Yeah, and indeed, cybersecurity risk governance is on the spring Red Flex agenda for 2021. And Teresa, your point is spot on in that there are many stakeholder interests that need to be balanced around this question of disclosure. And so it's not so simple as just saying disclose when there's an event, because of the impact to the company, to the reputationally, as much as it also will require consideration of impact to national security interests. One item I would also add here is, as it relates to the unfolding proposal, I think that's going to be sometime in October 2021. It's part of the overall ESG, the governance side of ESG, and so it will be interesting to watch this space to see how much will they put, a prescriptive guidance around this current state.
Okay, I think next slide.
Yeah.
So I'll be quick with this one, but and again, just the chairman being very proactive, even in his early days. For those of you know what 10b5-1 plans are, basically it's a plan for insiders in public companies, shareholders, officers, and others who have access to material non-public information, and allows them to develop a plan before they're thinking about buying or selling securities. And so they can have an affirmative defense to any allegation that, hey, you sold or you bought these securities during a period of time when there was either positive or negative material non-public information about the company, that you had access to it, but it was still not outside the market, in which case would lead to a civil and possibly a criminal prosecution. And so years ago, Rule 10b5-1 was a plan was set up to, or regime was allowed to have a plan where an executive could basically set it and forget it, kind of a situation, and that way you could say like, well, I don't know what's going to be in 6 months. I'm going to sell in 6 months. I don't know what's going to be material, not public then, but I'm going to just sell it. But and it's a big deal. We defend a lot of folks in insider trading cases, and it's a big deal when you have one of those. It's a major roadblock to the staff to be able to overcome that if they actually have this. But the chair recently, earlier last month, really took on 10b5-1 plans and suggested that there are too many people who are not acting in good faith, and in his words, have led to real cracks in our insider trading regime. And part of the problems are that people can trade almost immediately after establishing the plan. There's no cooling off period, which he thinks allows for abuse. They can be canceled. In which case, if there was going to be a sale, in theory, one could cancel the entire plan and cause it not to happen if there was positive material information coming out. There's no mandatory disclosure requirements that insiders have to give that they actually have a plan and what their plan says. And the last thing is that there is no limits on the number of plans. And so you could kind of pick up, down, sideways with a number of plans, and then just cancel the ones that are not moving in your direction. And from a distance, you could say that would be abusive. But and what he's directing the staff to doing, and he said in the speech, I want the staff to take a look at this again and see if we can come up with a new way to kind of really cut down. I know, Teresa, you've designed 10b5-1 plans for officers. What does this mean to you?
I think it's important here in designing the plans and in disclosing them, and even contemplating what the strategy is to having one or multiple plans, is to look at these 4 different factors, right? That the chairman has laid out that he finds problematic, and then try to address them. So it's really working closely with counsel right now to possibly have one 10b5 plan, for example. Have a lot more disclosure about, when you're adopting them, modifying them, canceling them, things like that. So that would be my thoughts, is just to really focus in on these 4 factors.
Yeah, what I like to do as a defense attorney, and I like to use my adversaries' words against them as a general rule. And so, if I was defending an executive in an action, I would go right to the chair's comments. If insiders don't act in good faith when using 10b5-1 plans, we're not going to allow it to offer an affirmative defense. You can't do that with a stroke of a pen. I mean, there has to be regulatory change for it to happen. But if you do show good faith, and if you do actually, meet with counsel, and you do actually, get rid of some of his perceived evils in these 4 factors, and so you really want it, it's going to be much harder to get the staff to get an authorization if the chairman's saying, hey, listen to me. Okay, we're going to do this. We're going to keep our plan and we're going to keep our affirmative defense, but we're going to tailor a little bit so these abuses that are not there. So my recommendation to people out there who have these plans and want to enjoy these protections is to just voluntarily take a look at the plan and see if you can't, maybe not have multiple plans, or maybe agree to a voluntary cooling off period, in which case, if you eliminate the criticisms, you're more likely to be able to allow defense counsel like me to actually make good work and avoid an action in the first place. So I see we are at 2:41, which means we have 19 minutes left. And so I am going to be accelerating the pace for Sandy. I think if she picks up crypto on the next one. So I'll go to you. Try to hit it in 50 minutes, okay?
John, you picked some really big topics, and a lot of them in hours.
I picked the best panelists who can hit the ball hard. So
yeah. Okay, great. So crypto, the challenge has been, the criticism has been, the concern has been in the crypto community is that the absence of really legislative and regulatory foundation to guide the innovation as it's unfolding now. So it's been a regulation by enforcement, quote unquote, and the issue there is obviously it's circumventing the normal procedures around regulatory creation, and that includes noticing, public comment, a healthy open debate, and it also might introduce concerns around rule of law, right? The regulators, preference and proclivities is what's going to drive where they will go and what they'll enforce. There's also some concerns that, well, it's not a concern, but perhaps it is, that there's an advantage to the first movers in the crypto space. We are now where we are. The tokens that are out there are already established, although there may be some relooking at going forward at the current suite of tokens. And overall, in terms of where the Chairman Gensler may be here is, he's going to want to balance the investors and protecting the investors, both from the concerns around crypto itself, the crypto exchanges, and then these decentralized finance platforms. But at the end, the other side of that coin is to foster innovation, not dampen innovation and investment. So, this is probably going to require some congressional involvement. The courts will be involved. There are cases in the courts already, but Congress certainly to lay down some foundation around this. And it also then causes, some more clarity around, which regulators might actually be over the crypto space. Is it the SEC? Is it CFTC? And then, it can survive through legislation can then help survive sort of changes in administration. Very recently, last week, Senator Warren actually sent a letter to Chairman Gensler. I'm not going to read this to you because this information will probably be provided and you can just get the letter. It's publicly available, but she certainly does outline some of the, critical questions that the SEC needs to think about in terms of the assets themselves, the exchanges, and these other platforms. and vis-a-vis their own authorities to regulate the space and protect the investors. So let's move ahead. Next slide, thank you. Curiously though, crypto is not in the spring 2021 rulemaking agenda. So I think that's a signal that Chairman Gensler is looking for Congress to be involved, but he will use what is available to him. He stated this in his public addresses, that he will enforce using current regulations around securities to protect investors. And thus far, I think there's been probably about 75 enforcement actions, SEC enforcement actions involving digital currency, digital assets in the last half decade, about maybe a dozen of those in the last 6 to 9 months. These fall in the categories of primarily unregistered coin offering, false and misleading statements, fraud, and promoting without disclosing positions. Very clearly, Chairman Gensler has stated that he feels that there's insufficient protection for investors in these crypto exchanges. Examples of those that he's raised is, the accuracy of information and disclosures that you get from these exchanges, the access to the investors when they need. And so he's, the second pillar of the SEC's mission is around fair, orderly, efficient markets. And when investors are not able to, crypto owners aren't able to trade, that's a problem.
Right.
Custody questions.
So Sandy, yeah. I think we have to final word on crypto, and then we're going over to Teresa for SPACs.
Final word on crypto, watch this space. Actually, not so much the space. If you wanted to understand how Chairman Gensler will potentially steer this ship, I think you only need to look at what he's done with the CFTC in terms of the swaps that were at issue in the financial crisis, and how he navigated that through enforcement and regulation and legislation. And then secondly, watch YouTube, because he was in the private sector as a professor in MIT teaching not just crypto, but blockchain and really fintech generally. So there's actually a lot you can glean from where his head might be going forward.
All right, now what can we glean about SPACs, Teresa?
So SPACs, people have been doing them for decades, but more recently in the past, 18 months, they've really picked up, and they've gotten a lot more focus as a result of that. So just, first, generally for people who aren't familiar with SPACs, they're special purpose acquisition companies. And it's pretty basic how it works. There's basically a shell company that goes through an initial public offering. And the whole purpose of this company, it becomes a public, it goes through the IPO, and then has no operations. And the intent is to find a target of a private company who wants to be public. And then traditionally it's a reverse merger business transaction, so that the target, the private company, then merges into the SPAC, and it's called a de-SPAC process, so that the private company can become a public company. And so it's this is, how private companies are going public in some ways, instead of going through their own IPO process. And traditionally, people have thought it's faster for the most part. And at some points, people think that there's less securities risk going through an IPO this way, or becoming public this way. And, with these being so popular recently, there was actually a recent, the SEC weighed in recently in April of this year, where the then acting director of corporation finance released a statement, and he really kind of clarified the application of the securities laws. And this didn't really get as much attention as I had thought it would. But he kind of signaled that SPACs are going to be getting the same scrutiny as regular IPOs. And I think there's an enforcement there's an enforcement principle here, and that companies are going to start getting looked at. The recent SPACs are going to get looked at to see whether or not they did indeed, comply with all of the securities laws. And something that was really interesting in there that he said was about forward-looking statements. So there's different types of liability that you can have, under the securities laws, and we'll talk about a couple of them that are directed really at SPACs. But this was particularly interesting because the Private Securities Litigation Reform Act provides a safe harbor for forward-looking statements. And traditionally, companies have been able to rely on this for their forward-looking statements. And this is in a public, in a context for the public to bring actions, not the SEC itself to bring actions, but that it had a little bit more leeway when it would say, this is a forward-looking statement and I could end up being wrong for all of these various reasons, and they disclose why their forward-looking statement might be wrong. But there's exclusions from this exemption or from this safe harbor. And one of those is with an initial public offering. And the then acting director, he noted that that's not actually defined. And so the de-SPAC transaction, he said, could be an initial public offering, which would mean that this safe harbor for forward-looking statements that people have oftentimes relied on for the de-SPAC process, the de-SPAC transaction, wouldn't apply. So it was interesting the kind of depth that he got into about all the different securities laws and potential liability of SPACs. For those undergoing SPACs and de-SPAC transactions, the real, kind of core issues that he focused on is disclosing conflicts of interests. So oftentimes, the management who creates the SPAC and is going to go look for a target, they're also called sponsors. They are able to sometimes, they're able to buy the shares at a much, much lower price than the investors. So investors, traditionally, it's about $10 a unit, which is equal to a share. So investors might pay $10. Sometimes the sponsors pay a penny, maybe less, could be more, but it's usually less than $10. So the financial incentives are much different. And for when the management has identified a target company and whether that business transaction is actually in the best interest of the shareholders and it is a good transaction to undergo, the incentives are much different for the sponsors versus the investors. So really disclosing and making clear those conflicts of interest are important. And that's also really important too, because, under state law, there's a lot stricter standards when there are conflicts of interest. And then the other part is projections. So in this statement, he also indicated that they would be focusing on the projections, forward-looking statements. And, if you have 3 different sets of projections, all of them based on what you consider to be reasonable factors, and you only disclose the most favorable circumstance, this statement, indicates that you'll be on, quote, shaky ground, which I think you can expect, to get looked at more carefully if you're disclosing only your most favorable projection when you have several different ones. So we expect to see a lot more scrutiny in not just upcoming SPACs, but recent SPACs too. I don't know if anybody has anything to add to that.
I think that's good. We just, you want to move to ESG?
Sure. So ESG, well, everybody's heard a ton about ESG. So pretty much everybody knows, environmental, social, and governance are what these stand for, but, they mean different things to different people and different things to different stakeholders, and different people focus on different ones. What's being focused on most recently, especially by the SEC leadership, is more around human capital and specifically diversity, as well as climate change. And so at this point, there is, over a decade-old guidance on ESG disclosure, but there aren't really set standards. So, it can be tough for people to know how they should be measuring ESG. What should they be measuring with ESG? There's so many different factors. So it's picking and choosing kind of what's, quote, material to your business, and then what's also material to investors. So it's a lot of your own kind of materiality analysis. There are some standards and organizations, and a host of them have come together. And last fall, they indicated that they were going to release more congruent and collective statements together. At least that was their goal. But just to focus on kind of two for people who are looking into more kind of disclosure with ESG, there's the Task Force on Climate Related Financial Disclosures, the TCFD. So these are climate-related financial risk disclosures that you can look to help you and assist you with disclosure in that area. And then there's also the Sustainability Accounting Standards Board, the SASB, and they have a variety of different industries that are supposed to help people with specifically their SEC filings to provide investors with comparable information. So investors and financial analysts can perform ESG metrics and analyses. So it does sound like FASB, which oversees financial accounting standards, but it's not a government-sponsored agency. It's just private actors. So I think that's important to note. And once you do decide to disclose ESG factors, oftentimes people are putting these ESG issues, risk factors, and various things in 10Ks and their proxy annual reports, their website. They have separate ESG reports and earnings calls. But it's important to remember that even if these things aren't required and you're just stating them, that the securities laws do apply. And so a couple things that are important to note here is, when you say something, even if it's not required, it must be true. And so even if it's not a required disclosure, it must be true. And the second is that you have a duty to update it to ensure that it's accurate. So those are, important to focus on if you do decide to start making ESG disclosures.
All right.
And I think the next slide, we'll just talk really briefly about the SEC's recent initiatives in this area. They've been announced on the 2021 examination priorities. They're reviewing the climate-related disclosures. And really significantly, I think for us, is the SEC announced an enforcement task force that's focused on climate and ESG. And these are a task force of 22 people who've been added to the Division of Enforcement. So this isn't a 5-person task force, it's a 22-person task force, which is pretty significant. And in the Division of Enforcement. So I think, that gives a really strong indication that ESG related disclosures are going to be significantly scrutinized.
Please record the code SEC2 for the post-program evaluation. Please make sure to write down this code if you're requesting CLE credit, as you'll be asked for it momentarily. SEC, the number 2.
So we do have, we're never going to get to it, but first of all, if anybody else has questions about topics that we covered, please feel free to email, any one of us about the topics. We're happy to, continue the conversation. One I saw quickly was, what does the SEC consider to be a reasonable cooling off period with respect to 10b5-1 plans? I don't know, Teresa, I haven't seen the staff actually say any particular. I've seen companies have a minimum of 30 and most of them have 60 days. But in my mind, as an SEC defense counsel, if I was going to be saying it was sufficient, it would be sufficient that any material non-public information had dissipated in one regard, or it become stale, or had been disclosed in some regard that the person wasn't acting with that information in mind, if you're going to keep it as an affirmative defense. Because again, at the end of the day, these things go to juries most of the time, and a jury is going to hear this instruction, and the jury is going to say, like, well, they waited 5 days, that's ridiculous. Oh, they waited 60 days, and the information went stale. That person's not guilty, or they're not going to fine for them. So you can't forget, even though this is technical stuff, it's very often decided by lay people. But with 1 minute to go, please, I want to thank Teresa, thank Sandy, thank Kristen, thank Jerry for help putting this together. I hope we packed a lot together in information for 60 minutes. Get your CLE and program survey. Let us know how we did so we can do better next time, if that's possible. I'm sure it is. I'm sure it is. But anyway, thank Sandy and Teresa. Thank you for everything for coming, and thanks all of the over 100 attendees who are here today.
Yeah, thanks everyone.
Thank you.
Okay, it is 3 o'clock. All right, thanks guys. See you next time. Kristen, anything else we need to do?
Yeah.
If you're requesting CLE credit, please complete the program evaluation form. I put it in the chat box. You can also scan it, scan the QR code to access on your screen, and we'll also provide it to all attendees after the fact. And if you have any questions, please reach out, and we will be following up in the next 48 hours with a copy of the slide deck, a link to the recording, and Sandy, Teresa, and John's contact information should you have further questions and want to continue the conversation. Thank you very much, everyone.